Welcome back to another episode in our Making a Deal series. Today we're going to be answering frequently asked questions about making a deal. Yes, we believe it is most effective when we are friendly, fair, but firm. We know that in most deals, you're going to have bumps in the road, you're going to have surprises. So if you can have good rapport with the other side, it helps get through those and to not have those become deal breakers. And so we try to be upfront and to have that rapport back and forth, but yet at the same time very much aware that our role is to protect our clients' interests at the same time as we're trying to drive towards successfully closing a deal. I would very much agree with your question and your comment that having a team is very important. And not on every deal will there be a broker or an attorney, but on many deals there are. And the broker, their role, if I was going to summarize it, is they are helping to prepare the business for sale. A lot of times they are working with the seller to come up with the listing price. They are actively involved in finding potential candidates for buyers and then helping to facilitate the transaction. Oftentimes they are referred to as dual agents, which means they eventually are representing both the buyer and the seller in the transaction, as is allowed for under the law. The attorney, on the other hand, is a very different role, and that we will represent only the buyer or the seller into a transaction so that we have attorney-client privilege, so we can have confidential communications when we are discussing particularly important provisions, when we are negotiating with the other side, when we are drafting revisions or the original documents. We are the advocate for the client. And so then we, as part of that, will also be helping shepherd the deal all the way through the closing, and oftentimes working closely with both our party and with the business broker. One other component which I would emphasize too is having good tax advisor is essential. And we work closely with our client's tax advisor, particularly on such issues such as the allocation of the purchase price, which has significant tax ramifications. Yeah, working capital is essential. And really what that is, in layman's terms, is it is your operating funds for when the buyer has purchased the business to be able to float the business, if you will. Because normally when you buy the business, you may have a delay in when your revenues come in because you may have some accounts receivable. But yet your expenses, your payroll, purchasing new inventory will happen right off the bat. So you need that working capital to get you through and to have reserves, as we know business cycles occur. And so a lot of times that may be part of the financing that the buyer will get, is to have some financing of working capital, but it is essential. And probably the number one reason that businesses fail is they run out of working capital, particularly in that first year or so of a new business starting. We think that it is important an attorney who is able to communicate and deal with the other side is very important. As well, having experienced counsel who can really advise you about transactions of this type, what are important issues to be looking at, and how to negotiate on those issues. Someone who is creative in trying to solve problems, because problems will come up, who's responsive not only to the client, but also to the other side. One of the things that we find that is the number one deal killer is delay. We think another thing is having a strong business and accounting background, because numbers drive deals. And having an accounting degree or having served as a CFO, a controller, it really helps you speak the language. I would say that the vast majority of deals that we work on, the buyers have some form of an entity, whether it be a corporation or limited liability company, that the actual purchase is handled by. Two reasons really for that, with one being more important than the other. One is And when you're dealing with the public or others, liability risks are always there. And when you have an entity properly formed, capitalized, etc., the liability risk will be with the entity and not with the owners of that entity, where their own personal assets, which they've worked hard for, are all at risk. Another reason that we see a lot of people doing entities as well, setting them up, is in the world of business, a lot of times when you are signing something as the president, the chief financial officer, it just seems like there's a certain amount of clout that goes with that as opposed to just as an individual. Not as important as the liability factor in my mind, but it just seems that I see that out there in the world of business and commerce. Yes, they can be set up relatively quick. There are certain ways that help expedite the filings with the state, etc. And so it's not unrealistic that that can be done in 2 to 3 weeks. It can be even more expedited for some extra fees to the state in a matter of days if need be. A lot of times, if you have a month and a half in there while you're working on the transaction, that's more than enough time to get that all done. Good question. We get asked that all the time. Normally, once the buyer's been identified, you're looking at 2 to 3 months to close the deal. And usually that is because there is outside financing involved, and it will take the lenders 2 to 3 months to be able to be in a position to close. You also have other factors such as getting landlord approval for a new lease or a lease assignment. Other approvals as may be necessary. And depending upon the types of permit you may need, such as like for a purchaser of a construction business, if they don't have their contractor's license yet, that may take you some months longer. So we always tell parties to be looking at what are the factors that are going to take the longest and potentially delay your closing. But if for the normal deal, you're going to be 2 to 3 months. Sometimes we've had deals that don't have outside financing, year-end deals, and they have been able to be closed within a matter of days, but that's more the exception to the rule. It is not required to have a letter of intent, even though a lot of deals they do have that, to try to make sure there's some basic understanding between the parties on certain key factors, elements of the deal, such as purchase price, assets that are going into it, our liabilities are included, accounts receivable, is that going to be included or not? So we can find that to be a useful feature of a deal, but it's not required. We certainly have X number of transactions where the parties, after their initial introductions and due diligence, they go right to the definitive agreement stage. And contingencies are important, and it's an area that we spend a fair amount of time on in our purchase agreements. What they essentially are is contingencies are events, occurrences that have to occur before you're going to have an agreement close, the transaction close. So certain things such as the buyer successfully getting their financing, getting the necessary approvals from a landlord or others, those are the contingencies. If those don't occur, the parties are able to walk from the deal. But once they have occurred, you then normally are getting close to the closing, and that is one of the things that really sets the stage for finalizing the transaction and for the payment of the purchase price and transfer of the assets. Thank you for joining us as we answered frequently asked questions to making a deal. We hope that those were helpful.